All right, boys and girls, welcome back to Freedom Steel. Todd Vandermide, former NRA contract lobbyist and all around Illinois gun law guru. So, quick update here on California. So, a series of cases were heard in Judge Benitez's courtroom today. You had Duncan v. Becerra, the mag ban, Miller v. Becerra, the semi-auto ban, Miller v. Bonta, which was the fee shifting case. You had Rhode versus Becerra, which was the ammo bans and background checks, and then Fouts versus v. Becerra, which was a Billieclub ban. A couple of the last two were just status hearings. The real meat and potatoes came in the mag ban and the semi-auto ban cases, where the judge did a bunch of things. He sat there and told the state that they weren't going to need a lot of experts' testimony. There weren't going to be, there just wasn't going to be any of that stuff. That he'd read all the things, and so he'd read all the history. And I even commented about one of the alleged experts and that his findings could be rebuttable. But with that, he gave the state, who was seeking an additional 6-month delay from where we are today, and he gave the state 30 days to come up with a spreadsheet in chronological order from 1791 till 1888 about the types of laws or ordinances that were in, the bans they had, whether or not they were ever repealed, if they were challenged in court, so on and so forth. Then, so the state has 30 days to come up with this spreadsheet. Then both sides will have 30 days to brief on said spreadsheet, with 10 days after that for rebuttal briefs to each side's, what each side files. So it looks like in 70 days, we are going to see some final movement in the magazine ban and the Cali semi-auto ban. It seemed that the judge is intent on a couple of things here from what we've read, that he is intent on getting this case to the end, that we are at the final stages of this case. There's no need to rehash everything. Obviously, they're not making any new history out of 1791. It seems that he gave the state some time on this, but not their 6 months or the unlimited amount of time they were asking for. It seems that the state has been attempting to set up a reversible error claim to the Court of Appeals, and all the watchers are saying, and lawyers that were in the room today are saying, that what the judge is doing looks clearly to not play into the trap that the state is trying to lay for him and avoid any ability for the appellate court above to issue a reversible error ruling. And it sounds like they think that when this is all said and done and we win, that the judge is likely to issue an injunction, a full-on injunction against the enforcement of the semi-auto ban and the magazine stuff. That's reading between the tea leaves and just pure speculation on our side's part, but they're getting that feeling from what the judge is doing by court watchers. So the judge chose the upper limit of 20 years post the ratification of the 14th Amendment from 1868 to 1888. And it seems that he made some snarky comment in the courtroom that he chose 20 years as an arbitrary number, just as 10-round limit on magazines was an arbitrary number. So when the state was arguing for their researchers and all that, it also appears that there was some discussion that these researchers in 2017, when the case was filed, had been studying the issue for 20 years. And now you've added another 5 years to that, and it would seem that they have had more than enough time to study the subject matter at hand. And we don't need to reinvent the wheel. Obviously, they're not writing new ordinances from 1791. They wanted to bring in some 20th century laws and such. The judge wasn't real thrilled with that. Seems that they can add that as an addendum, but he openly mentioned that 1791 is the preferential time he's going to be looking at. The upper limit is 1888, but I don't think you're going to see anything after that admissible in the judge, from the judge's ruling. This is good news. This is really good news in that Judge Benitez is keeping these cases moving. He's not playing games with the state. He's not buying into all of their shenanigans. And so things are good. There was a motion in the fee shifting case today for the governor to intervene since the attorney general has ducked out. The attorney general lost the ruling on mooting out the case last week. And then a day after losing that ruling, he thought it might be better if he just announced he couldn't defend the law based on filings he had put out against the Texas abortion law and their fee-shifting provision. So not wanting to be an outright hypocrite and make the absolute contrarian arguments in this case that he is making in the Texas case as an amici, he thought it was best just to save a little face and walk away. Hence, Governor Newsom, fluff boy there, is trying to interject himself into the case at hand. So that is a quick down and dirty of what went on in California today. Everybody was eagerly awaiting this 12/12 status hearing on issues out there, hoping maybe we get another Freedom Week out of Judge Benitez, but that is going to have to be stayed for just a little while longer here. 70 days. It's not that bad. The state is not getting, the state wanted at least 90 days with another 90 days on top of it. He denied them that. We're getting, it's less than what they originally wanted for half of that. So with that, things are looking up in California. The lawyers said it was a good day in court. They thought all the big things went our way. So, we'll have more as it comes to us, but just for that, guys, keep the faith. New York versus Bruin is definitely paying dividends at this point in time, and we'll see where this takes us. But until the next time, frag out.